As Jonathan said, my name is Tracy Hudson. I'm with the West Virginia Division of Financial Institutions. I've been around for a long time and probably worked with a lot of you here in the audience. Been there for 31 years. I'm going to give you a little background on our agency first. It's a very small state agency. We have 29 people. We're led by our Commissioner, Dawn Holstein, who couldn't be here today, unfortunately, but she sent me in her stead. Of our 29 employees, we have 2 of those are part-time. We have 1 part-time examiner and 1 part-time administrative staff person. So together with Terry Shock, who's in the back, we administer the non-depository program. So we really don't deal too much with banks and credit unions, but in an agency as small as ours, you never know what you might be asked to deal with from day to day. But as of last week, our agency regulates 43 state chartered banks, 3 state chartered credit unions, 1,090 mortgage licenses, 2,800 mortgage loan originators, 106 money transmitters, and 3 regulated consumer lenders that have 30 offices in our state. So we have an attorney who, her name is Kathy Lawson, and she handles our consumer complaints. And thankfully, over the past several years, consumer complaints have diminished somewhat, fewer now than historically. We kind of pin a lot of that on the fact that consumers have some access to other resources via the internet, and they're trying to resolve the issues themselves before they get to us. Of course, we did have a huge uptick in complaints during the mortgage crisis, but those kind of leveled off after a few years. Lauren got the benefit of those when he was with the agency. Primary issues we're seeing from consumers these days have to do with fees. It could be loan fees, late fees, of course, fees that are added on during servicing, deposit fees, bad check fees. Those are the complaints that actually come in the office the most. And one of the ones that's also very common is deposit availability. If you make a deposit and it's not available, consumers don't understand what the law is behind that, so they would call. So we think that a lot of the issues are kind of resolving themselves due to increased efforts at consumer education and outreach by the various consumer groups that do a pretty good job of getting information out there. So we were asked to kind of talk about what's on the horizon for the agency and what we see out there. The big thing that is kind of the conversation amongst all the regulators is the FinTech sandbox. And I'm not sure if anybody might have followed the legislation this year, but there was a bill for the FinTech sandbox. And if you aren't sure what that is, what a FinTech sandbox is, it's basically a mechanism to create kind of a safe space to develop technological and innovative programs in any number of different industries. But a lot of the industries that we're seeing that are impacted by this are specifically the money transmission group. The sandbox allows the participating companies to operate in that space for about 2 years without benefit of a license or a bond and all of the regulatory, I guess, rigmarole that you have to go through to get a license. But they are subject to supervision by the regulator over that time, and there actually is a determination by the regulator as to whether or not the product is truly innovative or whether it already exists in the commercial space and is licensed elsewhere. So there's kind of a determination on both sides. And at the end of 2 years, they either go into a licensed activity or they just quietly fade away. There are several states that have sandboxes in place or legislation pending. The first sandbox that was established was in Arizona, and as of this month they have 6 participants. And if you read the list of the activity, it's kind of confusing even for a regulator. It has to deal with centralized wallets that deal with ACHs for unbanked individuals, a lot of cryptocurrency issues, personalized investment and savings programs that are going to come through your bank account, vehicle title loans via the blockchain. So since title loans aren't available in West Virginia, I'm not quite sure how that's going to work, but that's one of income sharing agreements where If you're maybe just starting out, you need some additional money, you pledge a portion of your income for years going forward to do that. The person who takes the risk on giving you that money may win, may lose. It's, it's a lot of it's very speculative. As a part of that, in July of 2018, the Office of the Comptroller of the Currency announced that they were going to begin taking from non-depository institutions applications for a specialized bank charter. Well, immediately lawsuits were filed both by the Conference of State Bank Supervisors on behalf of all the state regulatory agencies, and specifically by the Department of Financial Services in New York. And earlier this month, federal court did find that New York's argument was with merit because the special charter, the special banking charter, did not allow for the taking of deposits. And New York Department alleged, and the court agreed, that deposit taking is an essential task of banking. So I'm not really sure where that's going to go, whether the OCC will continue to pursue it or whether they'll just maybe drop back and adjust their program a little bit. With regard to money transmission, that's probably one of the areas in our agency that while we only have 106 people licensed under that entity, or under that license, it's very difficult sometimes to determine what actually the company is providing. We have companies that everybody's heard of that they issue traveler's checks and money orders that you see everywhere. And then we have people who have online cryptocurrency wallets where they have established an exchange, and it just depends on how the money flows as to whether or not it is regulated under state law or any law. So we get a lot of questions on that. We get a lot of flow charts, kind of like with most of our applications and information that comes in through our agency. It's kind of a follow the money sort of thing. So we'll look to see where does the money come from, where does the money end up, and if there is an obligation that the West Virginia resident, be it a person or a company, where does their obligation become extinguished? So with that, there was Senate bill this year in the legislature, Senate Bill 603, that had to do with the establishment of an exemption for payment processors. And we had long been asked to opine that that was exempt, but based on the way our statute had been written, we did not feel that the agency could do that. And we did not bring the bill, but the industry did. We worked with the industry on that and came up with some language that we felt like was satisfactory and protected consumers, in that when the biggest, I guess, example of a payment processor I can give you is if you have anybody who plays games on Facebook and they put in real money to play, get extra life or power or tokens, that money, Facebook collects that money. They are the payment processor and they send that money to the game developer. So that's one example. You'll have Amazon and Google both have products that they use that are actually, they're acting as an agent for someone else and just siphoning the money through. PayPal also. So those are all considerations that we had to make when we were looking at that statute. And the primary concern to us is, when is the obligation on the part of the consumer extinguished? And it's extinguished as soon as they give the money to that middleman. So based on state law, the way it was amended in March and goes into effect, I believe, on June 7th, the exemption will apply. So we'll have a lot of companies who will maybe drop off of our license list, or they will actually just, a segment of their business will drop off their license list. So as I mentioned, some of those companies are very large. Amazon, Google, and PayPal, they're all very big. So we have one examiner who does money transmission exams. So we do that under a compact with all of the other states in the US. Basically, there are a couple of states that don't participate. But so we'll send one person, and 5 or 6 other states will send an individual, and they do a unified work program. So it's a really comprehensive exam, and this is one of the areas we're especially proud of, because West Virginia has received an award for the last 4 or 5 years based on the strength of our one examiner. So she leads a lot of exams of some of the really big companies. As I mentioned, cryptocurrency exchange and e-wallets are big topics. We get a lot of those. So next on the horizon, we'll touch just a few minutes on mortgage. That's probably where Terry and I spend the most of our time. And we've had a lot of hot topics in our office on that, and is history about to repeat itself? We're seeing more and more companies developing the low doc and no doc loans, and the problem is that they develop those, or it might be even a federal program that they've grabbed onto. But the problem is there are still state laws that they have to comply with. So a lot of them have been really surprised recently when they've been examined to be cited for the fact that they have not provided their documentation for ability to repay or tangible net benefit, all of those that are still factors under either legislative rules or the statute itself. So we're kind of keeping up with that, and record keeping is also a big one. So we have a couple of examiners, and they're, in Michigan one week, in California the next, and Texas the week after that. So it's a really interesting job, but it's very much travel centric. So it's kind of hard to keep people from time to time. I'm not sure if you're maybe aware of, coming up in November of this year, federal law goes into play, which is the temporary authority to operate, which means that you will no longer have to comply with all of the state law provisions before you can act as a mortgage loan originator in the state. That bill is 2155, I believe. And right now, you have to take a test. You have to take your pre-license education of about 22 hours. And then you are required to take continuing ed every year. After November 24th, which also happens right in the middle of renewal season for us, they can come in and begin to work immediately, and we can't really do anything about it. There are a couple of caveats. They have to work for a company that's already licensed in our state, and they have to not been denied or revoked in another state. But they don't have to have their education or their testing completed when they come in. Now, we could go in immediately and tag them with the status of intent to deny, which is not probably contemplated by anybody who wrote that statute. But right now, we have one licensed person, and she does a great job at turning licenses around. But after the law changed last year and we did away with the individual state test for West Virginia, which we were one of 2 states that held out on that, we got about 1,000 applications for license within 4 months. So that volume is just very difficult. Now, these people have to pay the fee, and they have to apply, but they do not have to have met all those requirements. And that's not just, it's every state. So all the states are struggling with how we're going to administer that once it goes into place. And I think, much like unintended consequences that Mr. Mangano was talking about earlier, I think there are going to be some unintended consequences that happen here, because states are going to rush to deny people because there's a worry about, is there an implied right once you have a temporary license or a temporary authority and then it goes away. So it's a short period of time. I think they have to complete everything within 60 to 90 days, but a couple of bad loans can really resonate with some borrowers, and we hate to kind of see that if they aren't. Lenders will still be on the hook, of course, and they still have to be out there, but it is something that we're kind of anxious to see how it happens. In West Virginia, we've kind of been following other states. West Virginia does not have a statute that regulates student loan servicing that we're aware of. A number of the other states, there are 21 states that have either existing legislation or they've introduced legislation to focus on licensing, rights of the borrower, loan forgiveness, and establishment of other state loan programs. So we haven't seen anything in West Virginia on that recently. One of our areas that our agency is especially concerned with is privacy and security, and we have been really working hard to make sure that all of our examiners and staff are very well equipped in that area, and then dealing with licensees who have breaches and how that is handled, and we try to stay on top of all of that. So it kind of all just boils down to, how do you balance between a regulatory initiative and easing regulatory burden on the licensees at the same time. And that's why some of the joint exam programs, so you don't get examined by 50 states, you get examined 3 times by 5 states each, and it's just one exam product that all the other states accept. So innovation is good. We like it, but we just are trying to balance its promotion in a regulatory environment and maintaining consumer protections wherever we can. Thanks for inviting us today.